Ken Washington here with Educational Resource Paralegals Legal Disclosure. By continuing, you acknowledge that what I am about to share with you is not legal advice, but rather it is educational information. If you like this video, I want you to like it, subscribe, and also share. Let's get into it. We talked about the EEOC. That's the Equal Employment Opportunity Commission. And today we're going to talk just a little bit more about that process. So when you file a charge of discrimination with the EEOC, then you are referred to as the charging party. A lot of times you'll see that initialed as C for charging, P for party. Now your employer in this case is going to be referred to as the respondent. And a lot of times you'll see that abbreviated, just RESP. Okay, so after you file your charge of discrimination, generally your employer has 30 days, the respondent has 30 days to respond to the allegations that you have presented to the EEOC. Okay, so when you file your charge, you have to sign your charge. And it gets sworn in by the EEOC representative. When they receive your charge, what they're going to do is they have 10 days to send a copy of the charge to the respondent. Okay, the respondent has generally 30 days to write what's called a position statement. Now, a position statement is basically a statement from the respondent, and it also is a legal argument. It's their chance to defend themselves, to say and explain themselves and the actions that they took against you. And so they have generally 30 days to do that. The respondent can ask for more time. Generally, according to the EEOC's website, they will give a short extension if an extension is warranted. And that would need to be proven by showing that the respondent is doing their due diligence to gather all the information that they need in order to adequately respond to the charges that you've alleged. After the position statement has been received, then the charging party, you as the charging party, have the opportunity to rebut the position statement, to give your point of view on the information that the respondent has provided. Now, the EEOC will not just automatically give you a copy of that position statement. You have to actually request through the EEOC's website a copy of the position statement and make your position clear that that is what you want. Once you've made that clear and the respondent has sent in a position statement, you have a copy of that position statement. Now it's your turn to look at everything that your employer has said, examine it, and give your point of view on the facts and rebut the information that they have presented and produced. Now, generally, at least according to the EEOC's website, the charging party has 20 days to present their rebuttal. Your rebuttal could be just over the phone in an over-the-phone interview, or it could be in writing. Now, I think it's best if you have everything in writing. Just as a general rule, having things written down, it's easier to prove what you've said and what your position was on matters. If it's just verbal, then it's kind of up in the air. So now, here's a very key point. If you don't take anything else away from the educational information that I'm providing you, take this away. There is a difference between an excellent argument and a legal argument. There is a difference between an excellent argument and a legal argument. When you read the respondent's position statement, and you say, "Oh well, no, that's a lie. I can tell that's a lie," and you start just being very passionate, and you're arguing very passionately, and you're very logical, and you're very thorough in your explanations. None of that matters if you don't have a legal argument. And so what's more important is that you understand what the law says about the case that you've presented, and the things that the respondent has said in response to that. And once you know what the law says about it, then you can use what you know about the law in order to refute those statements. Don't try to refute the statements just based on your own logic or your own opinion, or even from a place of morality, because the law is not concerned about what's right or wrong. The law is not concerned about if they're good or if they're evil. The only thing that the law is concerned about is whether or not the law, as it is written, was violated. So don't be concerned about being passionate, articulate, persuasive, or it doesn't work like that. Focus on the elements of the law and articulate the most persuasive argument in the context of the legal elements that govern the case that you're trying to prove. Now, how do you do that? How do you learn about, okay, what does the law say about this? You have to study. You have to Google it. You have to maybe buy some books. I use several case law books that I've looked at. Mastering Employment Discrimination is an excellent resource as well. But then there's also some software out there. If you really want to tackle this thing and really get into the meat of it, there is LexisNexis. Then you have Westlaw. And then you also have Fastcase. Now these are all software platforms that legal platforms that you can figure out a lot of information about cases. Then you can start citing case law, and then there's also there's basically three categories of law. If you look at law as a general, as a big umbrella, there's three major categories that law falls under. If you remember back to school, you have the executive branch, judicial branch, and the legislative branch, and the law can be categorized from those three perspectives. But the main takeaway from this is to make sure that you understand the legal merits of the arguments that you're producing, and not just try to just be passionate about it and logical about it, because or argue from a place of morality, because the law is not concerned about that. If you like this video, I'd like you to like it and share it, and I look forward to sharing more with you.